Sound the defo klaxon. Big news. Lots of big news, actually. We have some developments in the Christian Porter case, including issues of when you can suppress details about a defence. The Peter Dutton case against political campaigner Shane Bazzi appears to be moving towards trial. And, in perhaps the biggest defamation news of the week, Deputy Premier of New South Wales, John Barilaro, is suing YouTube comedian Jordan Shanks, who is more commonly known by the moniker FriendlyJordies. So who is FriendlyJordies? Well, if you're asking that, you clearly live a better life than me. FriendlyJordies is what you would get if that song Hey Geronimo by Shepherd was transformed by an evil fairy into a puppet that spouted undergraduate political analysis. Okay, that was a mean joke, and I am sorry. But it is the topic of today's Legal Explainer video. Are insults defamatory? And in covering this topic, I'm going to introduce one of the really complex ideas in defamation law, the topic of malice. Let's get some general background on the Barilaro and Shanks case. Mr. Shanks put out a video himself explaining the case where, as best as I can tell, nearly every claim he made about the law was quite incorrect. And so I'm going to frame this video in a way that a person who watched that video can understand how he got the claims wrong. The FriendlyJordies YouTube account publishes two kinds of content. There's content where he's pulling this face, and it's in these videos that Mr. Shanks tries to explain something about politics or political media. He has very strong pro-Labour views, and he really hates the mainstream media, including the ABC. His argument is basically that everybody he dislikes is corrupt or stupid, and sometimes both. There's a video of his in which he tries to present structural legal problems to do with the media, but instead ends up making Sydney Morning Herald journalist Lucy Carter just seem like an absolute saint of tranquility and patience. The main complaint about these videos is that they are often very mean-spirited and uncharitable. They demonstrate misunderstandings about key concepts and aren't really able to articulate anything deeper than the fact that, rightly or wrongly, he really hates the current state of politics and political media. This is his other type of content, and I'm still not entirely sure what it is. He puts on wigs and does odd skits. They seem kind of pointless. This is John Barilaro. He's the Deputy Premier of New South Wales. He is one of the people whom Mr. Shanks considers corrupt or stupid, and therefore Mr. Shanks has done both kinds of video about him. In between drawing attention to news stories that, in Mr. Shanks's view, demonstrate corrupt behaviour by Mr. Barilaro, Mr. Shanks will make jokes about Mr. Barilaro's background as an Italian. There are a lot of references to Super Mario Brothers. Okay, so one popular way to think about this case is just to see Mr. Shanks as a clown poking fun at a political figure. And on this view, Mr. Barilaro simply can't take a joke and is using defamation law because he is thin-skinned. A different way to think about this is that Mr. Shanks is simply out to make scandalous accusations and is using jokes as a vehicle for damaging Mr. Barilaro's reputation. Let's work through the legal issue. Can mere abuse be defamatory? So here we have St. Barnabas and St. Paul. As many of you will no doubt remember, Acts of the Apostle chapter 15 has a fascinating little story that describes their parting of ways. It reads, Meta detinas hemras, Ipen bros Barnaban, Bolos, you rat dog, you absolute pig, I hate you with the whole of my heart. I am sick of hearing you and hearing the constant stream of noise that comes spilling out of your mouth. And St. Barnabas hears this paroxysm from St. Paul and he's like, what the hell did I do? And it's really awkward because St. Luke is sitting right there, jotting down everything that's being said for when he's going to write the Acts of the Apostles. And St. Barnabas is like, I don't have to take this. I'm going to sue for defamation. So, of course, St. Paul gets our favourite lawyer for our advice, She-Hulk. And She-Hulk reminds us all to go through the 3 elements of defamation. First, there is a defamatory imputation. Well, hang on. Maybe we don't need to go much further than this. St. Paul calls St. Barnabas a rat dog, an absolute pig, and that he was sick of hearing his views. But what is the defamatory imputation? There's no allegation of wrongdoing, and this is a classic defamatory imputation. There doesn't seem to be anything in the content that lowers St. Barnabas in the eyes of the community. This seems to be just an example of mere abuse. St. Paul was not seriously calling St. Barnabas a rat dog. There is some case law in all of this. Craig Coleman was the coach of South Sydney NRL team, and the Sun Herald published a piece of satire which claimed that South Sydney was performing so poorly because Mr. Coleman had a fractured relationship with his mother. Justice Levine of the New South Wales Supreme Court found that, as a matter of law, the material was so absurd that it simply could not convey the defamatory meanings, and so refused to allow it to go to jury. Graham McGuinness, on the other hand, was a senior constable in New South Wales who, apparently, was involved in a fatal shooting. Australian Hustler, published by JT Publishing, printed a cartoon which, although plainly intended to be humorous, seems to have accused him of being a bloodthirsty killer cop. Now, in this case, Justice Levine thought it was a borderline case, and he struck part of the claim by the plaintiff, but let other parts go through to the jury. And then we have Hanson, Young, and Bauer Media. So Zoo magazine, which is published by Bauer Media, inexplicably thought that it was wise or sensible to Photoshop Senator Sarah Hanson-Young's face onto a bikini model body. It was common ground that any reasonable reader would have known that this picture had been manipulated. The text of the article claimed that Zoo would do more to help asylum seekers if Senator Hanson-Young posed for a lingerie shoot. It was pretty weird. But Justice McCallum found that the article subjected Senator Hanson-Young to more than a trivial degree of ridicule. Okay, so what should we make of these cases? In some cases we have material that's so absurd that it can't convey defamatory meanings. In others we have material that's clearly weird but does invite significant ridicule. Now, at law, the high water mark is an 1800s legal case called Donoghue and Hayes. It says, if a man in jest conveys a serious imputation, he jests at his peril. You cannot murder a person's reputation in jest. Importantly, this question turns on the specific facts of the case. There's no general rule that comedy is quarantined from defamation law. There's no general rule that mere abuse is quarantined from defamation law. The question is always the basic one asked by She-Hulk. Does the material convey a defamatory imputation? Back to St. Paul and St. Barnabas. So did St. Paul defame St. Barnabas? Well, maybe St. Barnabas can construe some imputations, that the plaintiff is like an animal, the plaintiff has stupid opinions, etc., etc. But it's really going to be up to St. Barnabas here to demonstrate to the court that venting mere abuse actually conveyed those imputations. And that is a pretty hard task. Notice, completely hypothetically, that St. Paul didn't accuse St. Barnabas of swindling anybody, of committing perjury, or of committing wildlife. It was mere abuse. In the Craig Coleman sense, it was mere absurdity. There was no serious allegation hiding beneath the veneer. You cannot murder another person's reputation in jest. So, let's roll on to malice. Malice is one of the conceptually fun aspects of defamation law because it tangles around so many different ideas. But let's start with Barilaro and Shanks. Mr. Shanks, in his video on this case, repeats the claim that all he needs to do in order to win his defamation defense is prove the literal truth of the statements he has made. One example of this is that Mr. Shanks claims that Mr. Barilaro is a conman to the core, powered by spaghetti. Mr. Shanks then says words to the effect of, "Yes, I can prove this. Mr. Barilaro was the spaghetti-eating champion for 25 years. But that is mistaking what the truth defense is. Remember, the truth defense justification applies to the imputations and not to the literal text of the material. According to Mr. Barilaro's lawyer, the imputations conveyed include that Mr. Barilaro is a criminal and that he is a member of the mafia. For a truth defense, Mr. Shanks has to prove on the balance of probabilities that Mr. Barilaro is a criminal and a member of the mafia, which is going to be difficult. This gets us to the other defenses in defamation law. On this channel, you've seen a few of them. For example, Oscar the Grouch arguing the triviality defense when he defamed Big Bird. The most important thing to know about these defenses is they are for when you cannot prove the truth of the imputation. Whenever we're talking about defamation law reform, we are talking about lowering the bar. Under what circumstances should you, usually the media, be able to make unprovable allegations? Now, in defamation law, we have moments that we call privileged occasions. As a society, we think that community is better off if there are times when you can speak freely without having to worry too much about defamation law. And the privilege comes in two flavors. There's absolute privilege. Think of the floor of Parliament. It's called Coward's Castle for a reason. Anything said in connection with a proceeding of Parliament attracts absolute privilege. And we're not going to discuss absolute privilege anymore. The second flavour of privilege is qualified privilege. This is when the person making a defamatory statement is doing so for a reason that we, as a society, think is important. There are three elements to the statutory defence. The recipient has an interest or an apparent interest in having information on some subject. Interest or apparent interest isn't a mere want. We might imagine that there is some person who has a real interest in juicy gossip, and that's not a real interest for defamation law. A real interest is like a need to know. If somebody calls me for a job reference, the person has an interest in my frank and candid assessment of the person, even if I'm mistaken about some details, or if I say things that are unprovable. The second element is that the matter is published to the recipient in the course of giving the recipient information about that subject. This is a bit obvious, but it shows that defamatory material can be a bit broader than merely the information that the person needed to receive. Somebody calls me for a job reference, I give information to them that contains material that can be construed as defamatory, even though I didn't intend to convey that to the other party. Hang on, let's just make this easy. Let's say that I accidentally convey an imputation through an unfortunate choice of words. My qualified privilege defense is that this happened when I was in a situation of privilege, and so I get some protection. And finally, the conduct of the defendant in publishing the matter is reasonable in the circumstances. And this gets back to the core question that I asked at the start of this topic. Under what circumstances should you be able to make unprovable allegations? If somebody is making the allegations unreasonably, we normally do not think it should be protected. What does all of this have to do with malice? Well, a defence of qualified privilege is defeated if the plaintiff shows that the publication of defamatory matter was actuated by malice. Now remember, the truth defence is an absolute defence. Qualified privilege is not. It can be defeated by the plaintiff showing that the defendant was malicious in the publication. And malice comes to play in some other defences, but in qualified privilege it's front and centre. But what is it? So malice is tricky because it reflects a state of mind, specifically an unreasonable state of mind. Gatley, with reference to English cases, outlines 3 kinds of malice in summary. There's the malice of improper motives, and this is the big one. You had this circumstance of privilege, but you were really using it to advance some other purpose. The most memorable Australian case of this was Joe Hockey and Fairfax. Fairfax had run Treasurer for Sale stories, which Mr. Hockey felt was defamatory. Fairfax ran a qualified privilege defence, but Mr. Hockey claimed that malice had motivated the editors-in-chief of 2 Fairfax publications and the journalist involved, who is now a senior colleague of mine and can probably get me sacked, and so I'm going to be very, very careful in what I say here. Mr. Hockey said that these people had an improper motive, personal animus. Now, as the case goes on, we really only become interested in the motivations of this guy, Darren Goodsir, the editor-in-chief of the Sydney Morning Herald. Was he actuated by personal animus, and, therefore, was he actuated by malice? The court says yes. First, there was a history between the parties which looked a lot like Mr. Goodsir trying to get back at Mr. Hockey. Second, there was contemporaneous evidence that Mr. Goodsir dedicated a lot of resources to investigate Mr. Hockey in order to settle a grudge. The evidence available was that Mr. Goodsir was out to get Mr. Hockey. But the thing that really nails it is that Mr. Goodsir sends some emails where he says very unprofessional things about how he wants to have an issue related to Mr. Hockey nailed to the cross, that he really just wants to use the headline Sloppy Joe, he's dreamt about it for ages, and that he wanted a headline that would be hurtful of or damaging to Mr. Hockey. Okay, remember why we're here. These were imputations about Mr. Hockey that Fairfax could not prove were true. Fairfax then raised the qualified privilege defence to say that readers had a legitimate interest in knowing information about Mr. Hockey, that defamatory matter was published in the course of providing that information, and that they behaved reasonably. Or whoops, there's an improper purpose to the publication, therefore malice, and therefore the defence fails. So that's improper motive. Another kind of malice is the absence of honest belief. You can't have a privileged occasion for the purpose of telling outright lies. After discussing this, Gatley introduces the third category as a subset of this, reckless indifference to the truth or falsity of the claim. Now, if you know something is false, almost invariably you do not have the protection of qualified privilege. If you are recklessly indifferent to the truth, it is difficult to show that you behaved reasonably, and there's a pathway for the plaintiff to show that you are actuated by malice. Okay, if you're this far in, you are starting to get an intuition for malice. It's really when there's an improper purpose. You've got a sinister motivation for publishing the defamatory matter, or you knew it was false and so therefore couldn't have had legitimate interest in publishing the matter. But there are some surprising things that are not indicative of malice. Bias, prejudice, and ill will. Stupidity is also on this list, as is just being mistaken about the facts. If you believe that you are providing true information, even if you are biased, even if you are prejudiced, and even if you are as dumb as a sack of potatoes, then malice will not be established if you had a proper purpose for communicating the information and acted reasonably. There's an interesting puzzle that arose out of the defamation case between Senator Sarah Hanson-Young and David Leyonhjelm. Ultimately, on appeal, Mr. Leyonhjelm lost his qualified privilege defence for reasons unrelated to malice, but even then, malice was proved. The court split, with the prevailing view being that Mr. Lanholm was motivated by a desire to personally harm Senator Hanson-Young by publicly shaming, humiliating, belittling, and embarrassing her about personal matters. Mr. Lanholm got his facts wrong, says the court, because he had made assumptions about what he had heard based on what he was predisposed to hear. He was biased. He was prejudiced. He might even had ill will. This was not enough to establish malice. Malice was established when he published for the purpose of doing personal damage to Senator Hanson-Young. So, quick recap. First, you can't prove the truth of the imputation. This might be because the claim is false or you don't have the evidence to substantiate your claim. Next, you run a qualified privilege defense, saying that the audience had a real interest in knowing the information that contained defamatory matter, and that the defamatory matter was published in this situation of privilege, and that you acted reasonably in publishing the matter. Now, only if you get that far does the plaintiff's argument about malice arise in this part of defamation law. If not for them being able to show malice on your part, your qualified privilege defense succeeds. This will be a fun one to watch, I think. How will a court construct what it is that Mr. Shanks does in his videos? Does he behave reasonably? Is he motivated by a legally improper purpose when he publishes? Are his videos about personally humiliating the Deputy Premier, or are they about politically damaging him with proper materials? Insults and jokes, as we have seen, can be defamatory, especially when they are a veneer for serious allegations. So there's no just jokes defense. As we've seen, there might be a qualified privilege defense, but we have that question about whether he acted reasonably and whether he was actuated by malice. Now, there's also the possibility of a defense that doesn't usually appear in court cases, but that is going to be a separate video. So that's it for this one. I've been told that I need to say hit like and subscribe more, but more importantly, if you have questions about this or related areas of law, hit me up on Legal Reckoning on Twitter. Bye-bye.